All right, we're ready to get started with the afternoon session. I want to welcome all of you again for joining us this afternoon. For those of you that I might have missed, my name is Harold Hahn. I'm chair of the Higher Education Coordinating Board, and it's certainly my pleasure to be with you here today. Thank you again for taking the time to join us and for all that you do for the students in the state of Texas, in our communities, in our states. I'm assuming most of you had lunch and heard the presentation there, and I thought it was absolutely fabulous. I just never would want to try to borrow money from Michael back when he was a banker. We'll begin the afternoon sessions on how governing board members can offer effective trusteeship while acting ethically and avoiding conflicts of interest. And for those of you who have not been on governing boards, let me tell you, sometimes that seems to become a challenge. So I think you're going to get some very good advice this afternoon. I want to introduce you to Bill France. Bill is the General Counsel of the Texas Higher Education Coordinating Board. He consults with and advises the board and the commissioner on agency legal matters, including providing legal oversight and of support for policies and programs. Bill has been engaged in the practice of law, which I've always kind of wondered after 30 years why you still have to practice, but
Because we don't get it.
he has extensive experience in education, administrative law, labor and employment law, and general business law. He served as general counsel for several clients in the private sector, and he has litigated nearly 200 cases to conclusion, most of them favorable for his clients, I believe.
Absolutely.
In the public sector, he also has served as director of legal and enforcement sections, as well as executive director. Bill graduated from St. Louis University with a Bachelor of Science degree in accounting, debit on the left, credit on the right. The University of San Diego School of Law with a Juris Doctor degree, and the Georgetown University Law Center with a Master of Law degree. I want to tell you, since I've been on the coordinating board and then as vice chairman and now as chairman, Bill has given nothing but stalwart service. If it's something that he doesn't know, it's not I don't know, it's I don't know and I will find out and get back to you. He is a trusted advisor, an esteemed member of the staff at the coordinating board, and a friend, and I want to welcome Bill France.
Thank you, Chairman Hahn, for the very kind remarks. And welcome to all of our participants this afternoon. This section, as Chairman Hahn pointed out, will deal with legal rights and responsibilities of regents and trustees. What we intend to cover this afternoon is a panoply of issues that are set forth in a statute directing the coordinating board to put on this training on at least an annual basis. And let me just quickly run through a number of those. The role of the governing board at institutions of higher education, and the relationship between the governing board and the institution's administration, faculty, staff, and students. We'll also address the requirements of the open meetings law, which is Chapter 551 of the Government Code, as well as the open records law, which is Chapter 552 of the Government Code. We're going to cover conflict of interest law and other laws pertaining to public officials. We'll talk about any applicable ethics policies, that pertain to institutions of higher education. And then we're going to open it up to questions at the end so that you can ask any question that you wish to ask, even if it was not something that you believed was covered in the presentations. We're very fortunate today to have an outstanding panel of attorneys to engage you in these presentations, and I'm going to introduce them from my left all the way to the end of the table. The gentleman seated immediately to my left is Fernando Gomez. Fernando has earned degrees from the University of New Mexico, a baccalaureate degree, and then on to the University of Michigan, where he obtained his JD and a PhD in American culture. Dr. Gomez attained tenure at Michigan State University before deciding that the law was truly his love. He has acted as the general counsel for the Texas State University system for nearly a total of 25 years in 2 different stints with that system. And sandwiched in between, he was general counsel for the California State University system. He has authored several books and has lectured on higher education law and other legal topics throughout the United States and abroad. One of his proudest accomplishments was editing a book entitled A Texas State of Mind. It is the book that commemorates the Texas State University system's 100th anniversary, and that was about 3 years ago that Fernando did that. Seated to Fernando's left is Kabi Caputo. Kabi is a 25-year lawyer. He still practices too. We just don't seem to be able to get it right all the time. At any rate,
Mostly right.
mostly right. And he is a school lawyer who provides general counsel services to schools and to colleges throughout Texas. He's also a litigator representing schools and colleges in assorted types of claims, including constitutional law claims, Title VII claims, Title IX litigation, and labor and employment litigation, virtually anything a school district, or a college could confront. Kabi has been there and performed admirably. He is a graduate of the University of Texas at Austin with a baccalaureate degree and also holds his JD degree from the University of Texas School of Law. He serves as outside general counsel to Austin Community College, and in addition performs special project work for Alamo Colleges, Austin ISD, among others. He frequently speaks on school law issues, and finally he serves as an adjunct professor in Concordia University's Graduate School of Education. Donna Cornell is another longtime attorney, and Donna has been the Vice Chancellor for Legal Affairs and General Counsel for the University of Houston System since 2002. In these roles, she is responsible for all legal services in every area confronted by the University of Houston System. That includes, obviously, contracts, conveyances, employment law, constitutional law, taxation, gift matters, governance, open government issues, and any other applicable issues. She interfaces with the Board of Regents on a regular basis and provides advice to the Chancellor of the university on a daily basis. Donna earned her undergraduate and law degrees from the University of Texas at Austin, and prior to assuming her position at the University of Houston System, practiced with the Attorney General's office as well as in a private law firm and went back to the Attorney General's office after the private law firm to become the Deputy Chief of the General Litigation Division. So, as you might surmise, Tana has a wealth of litigation experience as well. Please join me in welcoming our distinguished panel. And now let's get started with the program. I'm going to ask Fernando Gomez to go first, and he will address primarily governance issues, governance and related issues. If you have a burning question as we're going through this process of making this presentation, and you're concerned about waiting to the end because it just might not seem quite as relevant or maybe not as apt, please feel free to go ahead and ask it then. If not, we promise you there should be time at the end to ask plenty of questions.
Thank you, Bill, for the kind words. Chairman Hahn, trustees and regents, I think you're entitled normally to an introductory story or a joke, and I have one to impart as I don't take myself too seriously. Bill said some very nice things, and I very much appreciate it. But when I got married, and the year after I got married, I received my bachelor's degree from the University of New Mexico. That was the same year that my brother-in-law received his high school diploma, and we were at a family gathering at my wife's house, her parents' home, honoring the both of us. And now, her grandmother was a lady, probably late 70s, early 80s, who, from rural New Mexico, had raised 4 or 5 girls all by herself. Her husband died very, very young. She was on Social Security at the time, bringing in $89.23 and living with her daughter and son-in-law. When she comes up to me holding an envelope, small wisp of a lady, very, very slender lady, holding an envelope, and she hands me the envelope, and one to me and one to my brother-in-law, and I open it up, and there's a card in Spanish of congratulations, and a holy card, which is a picture of a saint with a prayer or something about the saint on the back, and a nice note telling me how proud she was of me, and signs it with her name, or with her initials, AUR, and a 20 and a 5. This is a lot of money for this lady. So I thanked her profusely, but what touched me most is that her own grandson received the exact same gift. And it's been a lesson that I've had all of my life about how to treat people. Anyway, when I finished the law degree 3 years later, she comes up to me with an envelope, and I said, "No, Grandma," I tell her in Spanish, "No, it's just not necessary." And she says, "No, tengo tanto orgullo, I'm very proud of you, para ti, for you." And I open it up, and there's a religious card, a nice note, her initials, a holy card, and a 20 and a 5. Well, when I finished my PhD 4.5 years later, she comes up to me with a twinkle in her eye. She's got her hand on her hip, and she's tapping the floor, and she's going like this, and she says, "¿Cuántas veces más vas a graduar tú?" How many more times are you going to graduate? And I told her, "Grandma," I said, this is the last time, la última vez." And she says, I said, I've received my doctorate. "¿Eres doctor?" "Sabes que tengo un dolor aquí." She could never figure out the utility of a PhD, and I guess I've never forgot that, never forgotten her. But what we're going to talk about today, as Mr. Franz indicated, is responsibilities of governing boards, system administrations, and institutions. If you pull out your materials, you will find 3 single pages that pertain to what I'm talking about today. The one says Texas Education Code, Chapter 51, and in particular, you want the one that says Section 51.351. I'll give you a moment. I can tell you that what the legislature has here is a definition and a guideline, an imperative, because it's a statute about how these boards are supposed to behave and how they're supposed to interact with the institutions that they serve. There are four general imperatives under section 51.352, and the legislature defines three things that principally that boards do. Now, there's more items than three, but the three principal things are: A, the traditional role of board members essentially is to preserve the institutional independence, the right of the board to govern its own affairs and to manage its own affairs through chosen administrators and employees. Secondly, the board has a statutory duty that statutory duties that are laid out there to establish goals, to name the chancellor, to name and assist the president, to set admission standards, and to make clear to the Texas Higher Education Coordinating Board its position on important matters. Under the traditional role, the imperative is to enhance the institution's public image, in addition to the institutional independence, to act as a liaison with the community, to nurture each institution, and to state a clear mission. And then finally, there's the fiduciary responsibility of managing money and managing the institution and state resources that are entrusted to the board. If you go to the next chart that says Texas Education Code Chapter 51, 51.353 says that system administration fundamentally does two things as I see it. One, it coordinates the activities of component institutions, and two, they lay out the statutory duties to the component and basically provide support, technical assistance, legal, financial, and they assist the institution. Now, very tellingly, when you come to section 51.354, now what are the institutions supposed to do? This is very substantive with respect to the academic mission. This is a focus on the academic mission, to transmit culture, to extend knowledge. This is noble stuff. To teach and train for the professions, to promote research, to protect intellectual exploration and academic freedom, to strive for intellectual excellence, to provide post-secondary education, and to provide continuing education. Now, the duties and responsibilities of each are really quite clear. And nowhere, and I'm going to get to the chart on duties and ethics of public sector board members, nowhere in this statutory scheme does the legislature give a mandate or an imperative to a single regent. You are the owners of the property, the real estate, the buildings, the books in the library. You are the legal owners of those institutions as a board, not as individuals. I know and I've seen and that we, in my years with the Texas State University system, that we've gotten a superb group of regents historically, just a marvelous group of people, accomplished people, business people, people in the professions, people who have achieved a great deal of success in life. But when you come to this milieu, you may run a multi-million-dollar company, you may run a law firm or a medical center, whatever you do in life, you act only through that board. That's very, very critical. A public board, as Mr. Caputo will tell you, functions only one way, can act in only one way. At a public meeting, publicly called for with a quorum present by a majority vote. That's it. And there is, now you will ask, and you may ask of the chancellor or of the president, if you have a board that, where the president reports directly, you may ask that certain initiatives be put on the agenda. You may work with the chair or your committees about putting initiatives on the agenda. If you want a report on faculty retention or diversity, whatever that report might be, whatever that document might be, it has to go through process. Because if you ask, I guarantee you, if you ask a president to do something for you, or a vice president, I think you're really going beyond, if you're in a system, the chain of command. But if you ask them to do something for you, they're going to do it for you. We had a regent years ago who lived in the community, and she was very devoted to the university, a wonderful, wonderful regent, served as chair of our board. Didn't like the fact that they had planted begonias outside of the tennis court complex, and she commented to the president that she didn't care for the begonias. Well, the next time she gets onto the campus, they had dug up the begonias and put something else in its place. Be careful what you say. These folks are going to listen to you. Now, we're going to talk about ethics. If you turn to the duties and ethics of public sector board members under Texas law, I'm a great one for symmetry. I love symmetry. There are 16 imperatives, 16 guidelines here. The first deals with general authority and duties of the board. The most significant one is independence. If you are appointed by the governor with the advice and consent of the Senate, you are a state officer. You may be removed only one way, through the impeachment process. Not even the governor that appointed you can remove you. Now, I don't want you to misunderstand this next piece, and maybe I should ask for the camera to go off for a while, but just kidding. I don't want you to misunderstand this. You will get calls from the governor, any governor. I'm not talking about our current governor, I'm talking about any governor. I've seen it happen over 25 years on a number of occasions, suggesting that you make a certain choice for chair of your board, suggesting that you should engage in certain initiatives. And I think the response is, Governor, I thank you. I will bring it up to the board and we will talk about it, because your job is, even if he appointed you, is not to do what the governor asked per se. I think you should listen to the governor. I think you should listen to the legislature if somebody calls you. But I think at the end of the day, it's your decision what is in the best interest of that institution. I've heard people say, we need to advance higher education in the state of Texas. Incorrect. That's not your role. Your role is to watch after the institutions that you are charged with governing. That is your role. The role of looking after the institutions and public higher ed in general is something that's given to the Texas Higher Education Coordinating Board and its commissioner and their staff. And that's a coordinating function. It's something that they work with us constantly in concert with institutions of higher education. But again, I'm not telling you to be disrespectful, but if you take nothing away from what I tell you, take away the concept of independence, and with that, acting as a board, not as individuals. You may have the best idea in the world for a new building, for a new program, but it has to run through that process. And I have people on my board, and as I said, I've always had people on my board that are very, very distinguished and accomplished in the business world and professional world, but they've spent a lifetime at it. What you need to remember is that as you as trustees and regents have spent a lifetime in your profession, the people that you're working with at the university, the folks that you're working with at the coordinating board, have also spent their careers, many, if not most of them, in higher education, working in higher education and learning their craft. If they're not doing something that you feel or heading the institution in a direction that you feel is appropriate, then as a board, there is a remedy. You can make a change, and that happens sometimes. But you're again acting constantly as a board. Let me talk a little bit about the duty of loyalty. And it says up here that a board member must be and by the way, what I've given you here either comes from statute or from Robert's Rules of Order. And I guess the fourth quadrant of this, relationships with the chancellor and staff and presidents, also comes from, I suppose, experience, common sense of dealing with these issues over the years. But it's a very slippery slope. We've heard about the Penn State situation and what the problem was there. The problem was a loyalty to an individual. When you're on a board, even if you were a graduate of a particular institution, if you're working with a system, or if you become very close or you live in a community and you're very close to the president and the board decides to change out the president as a group, as a majority, the loyalty, again, inures to the institution, not to the person. And the problem at Penn State is the loyalty was to the football coach. And we think, well, this is not something that's likely to be replicated. That particular fact situation of the child abuse and so on probably is not. But the concept of misplacing your loyalties is a very real one. And you need to be very watchful of that, and I hope that you will be. You should ask as you come onto the board three fundamental questions, I think. What do I have to offer? Well, you have knowledge, you have the experience of a lifetime, you have relationships that can come to bear with the institution, either raising money or enhancing the institution in some way through your administrators of your own choosing. You may have a vision for the institution, and that's to be shared. Secondly, you should ask, why do I want to serve? The reason that you want to serve should never revolve around you, and I've seen very little of this over the years. It should revolve around the idea of doing public service, and I think most people come with that aim in mind. And then the third question is, how can I best contribute? We've had, for example, a gentleman who ran a construction business a few years ago up in the Dallas area, and he did an absolutely wonderful, wonderful job heading our planning and construction committee. Never overreached his authority, always worked within the system. If you're a lawyer, I love having lawyers on the board because I can explain the law to the board as I see it, and I think the lawyers get it. And I think most of them that I've worked with, if not all of them, have always respected the background that I have brought, but I have always contributed. We had a particularly messy personal injury case, and I brought in a demonstrative exhibit of a girl was hit with a baseball bat by accident. It was a very old bat, and to make a long story short, I brought the bat so that they could see what the problem was and why we would, in fact, want to do a settlement. And the regent, who was a lawyer, said that was very effective, and that as the board deliberated, they realized that this was the right thing to do. So it's a good thing. You have things to offer. You have important things to offer. You have important wisdom to offer. But again, the process is critical. The process, maintaining the division that the legislature has given you, is very critical. Conduct at board meetings, and I want to let you, I'm talking about duties of the chair, and again, the chair may speak for and represent the board only under general grant of authority, may not take positions he or she knows is contrary to the board. Conduct at board meetings, there's a statute in Texas that says that if you have That's Government Code 651.003, that says that if a regent or trustee has a dissenting opinion on any issue, he or she has the right to have that opinion or a statement thereof read into and become part of the minutes. So it's obviously great if you come out if you come out 9-0 every time, but that's not necessary. You can and you should express your opinion. I've seen situations where two people have carried an issue where the board was wanting to go another way, and only for the board to eventually change its mind 2 or 3 meetings later to take the direction the two wanted to take. We have a system of checks and balances here. That's what we're talking about here. A system of check. You're part of the executive branch of the government. You're not part of the legislative branch of the government. I'd be very wary if a member of the legislature calls and asks you to take an administrative action or to have an administrative action taken. That's called separation of powers. This is a beautiful system. This is what the American Constitution, what the Texas Constitution is all about. It's about governing through a consultative and through an organized way where every unit that's involved in the governance process, every individual has a role to fulfill. And that's very, very critical to remember that. The duty of confidentiality, you're going to be in executive session with counsel, or you may be in executive session on a real estate issue or a personnel matter. And the law is very strict about this. The minutes of an executive session, and I don't want to get into Mr. Caputo's area too much, but the minutes or the certified agenda are absolutely privileged, and so you need to not come out of executive session ever and share your thoughts with somebody else. You could lose that privilege. Ms. Cornell is going to talk to you about conflicts of interest. The executive's role, I want to talk on the second page of this handout, relationships with the chancellor, staff, and presidents. As the statute says, you have to create an environment in which the president can succeed or the chancellor. Examples of policy which were within the purview of the board include the opening of a satellite campus. Obviously, the hiring of a president or chancellor, that's probably the most important selection, the most important duty you'll perform. Whether to sell land on the interstate, and then the matters that I told you about earlier in statute. What is not policy is termination of a vice president. You may not like a vice president, but that doesn't. But you do not have authority to terminate the vice president. I would not go to the president, even if the president reports to you, and certainly if the president reports to the chancellor, you do not go to the president and say, "Get rid of that person." You have to respect that separation. If you think that the president is not doing his or her job because of something that the vice president is doing, then the appropriate setting is an executive session when you evaluate the president to express your concerns, and then they're either addressed or they're not. If they're not, then you have the ultimate remedy of making a change at the top. Student discipline, that's not board policy. It may be, the worst scandal you ever saw in a particular town, but that's still not a board matter. Strategies for retention, the specifics of contracts, these are, again, not board matters. I think, just in summarizing, again, I come back to the concepts of loyalty and independence, most importantly, more importantly than I think anything else. You must act as a board. You must respect the chain of command. Sometimes it's very difficult, but work in concert with each other, and I'm sure that you will have a wonderful and rewarding experience that you will treasure for the rest of your lives, and that you will have done good for these institutions. Thank you very much. If you have any questions, I guess we're going to address them at the end, and I will also be around. I think we'll all be around after the session, and we can visit then if you'd like.
Thank you, Fernando. I'd like to now ask Kabi Caputo to come up and present on open government issues.
Thank you all. Welcome to the Leadership Conference. From Fernando's sort of noble and aspirational topics, we're going to sort of delve into something that's much more mundane, extremely mechanistic, and potentially punitive. So no matter how many times you've heard people speak about these topics, it ultimately is you are the one that would go to jail. So we bring it back every year. I do my best to keep my clients out of jail. I've never had one go yet. So batting 1,000 on that. I was an elected official for 11 years on a city council, and we did have some open meetings problems. Actually, conveniently, I was in 2 chunks, and it was while I was out of office that the severe problems came up. But it is never a good thing for any institution to have open meeting or open government problems of any sort. It just destroys your credibility in the community. Those of you that are trustees, be aware the first part of your title is trust. And if you lose the trust of the people, they lose faith in what it is you're doing, and all of you are doing extremely good things. And so you shouldn't do anything that's going to compromise the public's trust that you are extremely above board. So as Fernando mentioned, it's impossible for a board, whether it's Board of Regents or Board of Trustees or City Council, to act except at a meeting. And the meeting has certain prerequisites to it, but we need to sort of stop for a minute and say, well, what is a meeting? Some people don't know exactly how it's defined, and the statute is very precise. So a meeting is defined as a deliberation between a quorum of a governmental body or between a quorum of a governmental body and another person, during which business or public policy over which the body has supervision or control is discussed. So right there's a couple of words we need to define. What is a quorum? What is deliberation? But importantly, I want you to think about, it's not just when you're talking with each other. It's if someone is talking to a quorum of the board. And that's a thing that is hard for some folks to grasp, that we're not meeting because we're just listening. But if a quorum of you are present and public business is being discussed at you, you are in a meeting. You can kind of go biblical and say wherever 5 or more of you are gathered, there is a meeting. So what is a quorum? And the answer is generally a quorum is a majority of your body. So if there are 7 of you, it's 4. If there's 9 of you, it's 5. If there's 11, it's 6. But a majority, a bare majority is a quorum. So we were fairly cautious when I was on the city council, even to the point of if we were at a restaurant and there were a group of us and we counted and realized there were 4 of us in the restaurant, one of us would leave. Just because we didn't want people coming in later and saying, oh, you guys got together, in the hall by the bathroom or, back by the kitchen and you plotted something. It's just easier, because how do you disprove that? All you can do is say it didn't happen. But if it's out there, it's out there. So we were fairly circumspect about, oops, somebody just walked in, I'm going to leave and, head out. So that may be extreme, but I'm extremely risk averse. I don't want to go to jail. I didn't want to go to jail. And I didn't want any more scandals to my city. And I'll talk in a few minutes about the problem that my city had. So a quorum of you is a majority. And then what is deliberation? And again, the statute, the open meetings law, defines it for us. And it says deliberation means a verbal exchange during a meeting between a quorum of a governmental body or between a quorum of a governmental body and another person concerning an issue within the jurisdiction of the governmental body or any public business. So again, is there a majority of you there, and is somebody, whether it's you or some other person, discussing with you public business? And so it should be fairly simple, right? We just don't ever get together in groups of more than a quorum unless we're at a properly called meeting. The problem is we have technology, and we have people that find ways around stuff. That's what people think lawyers do, and many lawyers do that, but Really, it's not our job to circumvent the law. Our job is to make sure the law is respected and implemented. So there's something called a serial meeting where one trustee may call another trustee and talk about a topic. And that's fine. It's just two. That's not a quorum unless you're on a 3-member board. And there actually is a case about that of the PUC. I think it was the PUC. It was one of the state agencies. It was a 3-member board. They were having a hearing, an actual contested case hearing, and they took a break, and 2 of them were in the bathroom together, and they started talking about the case, and someone was in the stall and heard them talking. And that was deemed to be a violation of the open meetings law, that they were talking about the matter that was in front of them outside of that properly called meeting, literally at the urinals in the bathroom. So this is a fairly serious matter. So we have one trustee who's called another trustee and said, hey, this is coming up in the agenda. What are your thoughts? That's okay. Legally, it's okay. But what if that same trustee calls another one and then calls another one, to where he's called, between himself and the 3 he's called, he's now called a quorum. That's what the AG calls, what the law calls a serial meeting. So it didn't all take place at once. You weren't all present together, but the topic has been discussed among a quorum of you, and perhaps, not necessarily, but perhaps you've come up with I now know how everybody's going to vote. I know what's going to happen. So that's one thing to avoid. There are also now electronic quorums where you email back and forth with each other. And that has been a bit of a problem for a lot of organizations. I routinely now sign my communications to my boards that I represent with, please do not use the reply all button if you want to respond to this. Because I think the reply all button is just a open meetings violation waiting to happen. And you may not even notice. A lot of people don't even bother to look at who all something was addressed to, and you just hit the reply all and you pound out your response. But if it was a quorum of the body or the whole body is on the email and you've responded, then you've responded to the whole board and you are effectively conducting a meeting at that point. So you have to be very cautious about that. There's also something called a walking quorum, which is similar to serial, but it's instead of calling each other, you just walk around and talk to enough people that I know how the board's going to act. And then there's daisy chaining, which is a variation of a walking quorum or a serial quorum where I go talk to you and then you go talk to somebody else and then they go talk to somebody else. And we all know what everybody's going to do because they've all been talked to. That's a daisy chain event. I didn't talk to a quorum of the board, but a quorum of the board was talked to, and we all know what's going to happen. So those are the sorts of things we need to avoid. The situation that happened to my city, unfortunately, while I was out of office, was that a group of the city council decided they didn't like the city manager anymore. And they scheduled a meeting with the city manager at the city attorney's office, which I always found sort of ironic. And it was the mayor and 2 other council members. And at the last minute, the mayor decided he couldn't go, and he called a 4th council member, and we had 7, so 4 is a quorum, and said, hey, go to this meeting for me. I can't make it. And in the meeting, the 2 who were supposed to be there with the mayor told the city manager, we're going to fire you. Don't bother showing up at the city council meeting tonight. You're no longer on the job. And during that meeting, between 3 of them, the mayor called one of them and said, how's it going? And he said, oh, it's good. We've already told him he's not coming to the meeting. I don't think he's going to fight with us about it. And then the mayor turned around and called the rest of the senior city staff and said, we're going to have a meeting at the library at 1 o'clock. I need to talk to you all. And then the mayor and one of the council members who'd been in the lawyer's office went and met with senior city staff and said, the city manager's been fired. He's not coming to the meeting tonight. You, assistant city manager, or acting city manager. And no one knew what was happening, right? That just happened behind the scenes. One of the council members that wasn't involved in it all heard about it, and he actually called the attorney general and reported it to the attorney general. And the attorney general then came in and began investigating and was going to press criminal charges against the 4 that were involved in it. And that's when I got reelected to office. And as they all tailed out, and as my second tenure in office began, we had to wrap that up. And we wrapped it up by, we had to do a certain amount of training. This was before the days, you've all been through this mandatory training. It didn't exist at that time. We are actually why that exists now. Is that, yeah, so you're welcome. I've been through it a few times myself, and I actually give the training, so it's not any picnic for me either. But the damage to our city was terrible. That it came out in public that a majority of the council had acted unilaterally outside of public view to fire the city manager and basically take over city staff. And so that's egregious, and they deserve to be in trouble, and they all were put on probation and had to pay fines and things like that. So when you have your meeting, then you need to have an agenda. And this comes up sometimes, and I don't often go into this with y'all because you guys shouldn't be setting the agenda, but it is one of the issues that you need to understand. Whatever you're going to talk about at the meeting as a group has to be on the agenda in some form or fashion. The purpose of the agenda is not for your benefit. It's for the benefit of the general public. And what the courts have said and what the Attorney General has said is a member of the general public looking at that agenda should be able to tell what it is you're going to talk about. And so there are times that much more detail is needed. If it's an extremely important matter or if it involves a high-level official, a school superintendent. Actually, one of the cases was about a football coach, so kind of tells you the school superintendent or a football coach. You actually need to put their name or their office on the, you can't just say personnel. You need to say personnel city manager or personnel superintendent or personnel football coach. So the amount of detail can fluctuate depending on what's going on, but in general, if a member of the public can't pick up your agenda and say, oh, you're going to talk about selling some land, or you're going to talk about creating a new program and going to the higher ed board for approval, then your agenda is insufficient, and you can be prosecuted for having insufficient agendas as well. One downside to all this, besides what I'm pounding you with of you're going to go to jail, is your actions can be voided. I actually had a lawsuit that I won in South Texas where I represented one city against another city, and part of our attack on them in this case was to show that they violated the open meetings law in the actions they took. And we were successful in voiding every action they took. They took 18 different actions. In this illegal meeting, we voided every one of them, and we also, my city was awarded $125,000 in attorney's fees from the losing city. So it's a potentially disastrous situation. Some people go, oh, no big deal, they'll just void our action. We'll just retake it. But you don't want to, I don't want to at any rate. I'm more risk averse, I don't do that. So your agenda is important. Your staff should be the ones putting it together. Hopefully they're running it through legal review. I'm always surprised. I represent school districts all over the state. I'm always surprised at the number of them that they have no lawyers look at their agendas before they post them. And, crazy things happen. So a topic I want to cover is the notion of citizens communications. And I don't know, I've never been to a Board of Regents meeting. Is there usually a public citizens? Okay. This was surprisingly a controversial topic back in the 90s. The Attorney General determined, I think it was Cornyn, I can't remember if it was Cornyn or Abbott at that time, it was one of those two, determined that because citizens come and talk to you about things that are not on the agenda, that they can't do that because a quorum of the board is present, they're being talked to by a third party about something that's not on the agenda. And his initial ruling in this matter was there cannot be anything called citizens communications unless the citizens tell you in time to be put on the agenda. So they'd have to give you notice within 72 hours of the meeting what it is they want to talk about. You then have to post that on your agenda and say, Citizens Communications, Mrs. Jones wants to talk about why we haven't sold land or whatever. And a bunch of us, my city and several other cities and other governmental bodies sort of revolted at that because there's a provision in the Texas Constitution, Article 1, Section 27, that says citizens have the right to petition the government for redress of grievances. And if we're going to make them tell us 72 hours ahead of time and put it on an agenda, we're sort of infringing on that right. And the AG backed off, but only a little bit. And what he concluded, and this is why your meetings today run the way they do, is citizens can come and talk about whatever they want. And even though that is technically deliberation under the statute, he doesn't consider that to be a violation of the law. You just can't talk to them about it. And so you have all these lovely situations where people come and, if you're in a small community, this may be the largest body anybody's ever spoken to in public. People are shaking, they're nervous. They get there and they get out, they read their little 3-minute statement, and then you all sit there like bumps on a log and, occasionally wave at them, and they move on. And they feel like you don't care, and they feel like you're ignoring them, and they feel like, why did I do all this? And it's because the Attorney General won't let us respond. The only legal response, well, there's two. One is a member of the board can ask staff for, if there's a policy issue involved, what is our current policy? And staff can report what the current policy is, and that's it. And there can't be discussion about that, or maybe we should change it, or shouldn't it be this? Or a member of the board can say, I would like that put on a future agenda. And that's what you have to do, and you need to be able to tell the citizens, it's going to be on a future agenda, if you want to come back at that time, then we can actually engage in a dialogue. So the right of citizens communication is somewhat truncated, and I find it's just very awkward. to have people come and ask you questions and raise issues and sometimes rail and thunder at you, and you don't get to do anything back. You just have to sit there. And that was always hard for me because I'm fairly hot-headed, and so when people would come and yell at me, I would like to yell back, or I'd like to, show them how wrong they are, and I had to just sit there and bite my tongue. And luckily, I sat at the other end of the dais from the city attorney, so it was sometimes hard for him to. I may have said things occasionally I shouldn't have. So, but don't do that. I mean, that's But it's good at the beginning of the meetings, and I know a lot of presiding officers do this now, is they sort of explain that to the public that due to legal interpretations, we cannot respond. It'd be better if people understood that, but it's not something people pick up. So there are some exceptions to what is a meeting. For instance, if you have a quorum of people present here right now, technically there's a quorum of you present, we're discussing public business, you're listening to a third party. That is technically a meeting, except there's an exception in the act that says if you're attending a seminar or a conference and the discussion of public business is incidental to the conference, then that's okay. But if 4 or 5 of you are sitting around a table right now and you're passing notes about how you're going to fire the chancellor when you get back, that you're violating the meeting independently of this general assembly. And then there's another exception like that for going and testifying to the legislature and things like that. So Texas law is fun because they pass laws that sound good. You guys can't do anything without having a quorum present and an agenda posted. And then they realize, well, there's problems with that. And then they go in and throw in all these exceptions. And that's why I have a job. And so I thank the legislature more than I curse them, but I do thank them. So you can have something called a closed session or a closed meeting or an executive session, and that's where you go out of the public and you speak privately amongst yourselves. And as Fernando mentioned, you have to keep either a tape recording of that or a certified agenda. And those documents are confidential and cannot be read by anybody except a court reviewing whether you broke the law in there. So that's the sort of the fundamental premise for why this is confidential. But there's limited reasons you can do that. You can't just do it whenever you want. There's a whole host of exceptions. And in the materials, I think, on the flash drive is a handbook from the Attorney General about open meetings. And it's very helpful for y'all to look at that. It contains the whole statute, and then it contains many pages of the Attorney General interpreting it for you. And if you have questions about these sorts of things, you certainly need to talk to your own attorneys about it. But you can do a little homework on your own and look at what the Attorney General has put in his handbook about it, so you're sort of up to speed on where we are. But in general, there's very few reasons you can go into closed session. And even at times, even when you're allowed to, you might want to ask yourself, well, why do we want to do this in private? Why don't we just do this in public? A topic that may be on some people's minds who had November elections is it may be time to reorganize your board and elect a new presiding officer and officers of the board. Legally, you could do that and you could discuss that in closed session. You can't take action, but you can discuss that in closed session. But I know a lot of governmental bodies that say, the public should see us talking about that. It may get ugly. Bismarck's statement about nobody should see laws or sausage being made. It's oftentimes very sausage-like when you're arguing about who's supposed to be the presiding officer. And like I said, the law would allow you, because that's discussing the appointment of a public official. You could do that in closed session, but many people choose not to do that and to do that in open session. The reasons to use closed session generally relate to, is it something that for instance, you're buying land. You don't want to necessarily sit there on the dais and say, we're looking to buy this tract over at 71 in the toll road, and we don't want to pay more than this much money. Because you've then told the other party that you're buying from, or other people who might jump in and outbid you. So you're allowed to talk about those kinds of things in closed session, have your staff go make your offers and bids and things like that. You'll need to consummate the sale in public. You'll need to have a public meeting to say where you're now going to purchase it. But you can talk about that, so it doesn't give an advantage to somebody that you're negotiating with. The Attorney General is continuously whittling away at this, but you're allowed to go into closed session to talk with your lawyer about legal matters. You can't go in there and talk about anything. But if it's a legal matter, you're allowed to talk about it. You can talk about the legal issues and aspects of contracts. You can talk about the legal aspects of policies. You can't go in there and talk about, well, should we do this or should we do that in the policy? That's your discretionary decisions, and that needs to be done in public. And sometimes it's awkward in closed session. People kind of drift into things that they shouldn't, and it's the lawyer's job to kind of rein everybody back and say, we need to stick to what's on the agenda. And that's another issue, is what you talk about in closed session in some way should be on the agenda. It doesn't have to be extremely detailed. We're going in there to talk about buying land at, 71 and the toll road. But it can say we're going in there to talk about purchasing land in, the southwest Travis County or something like that. So the public knows you're discussing buying land, and they generally have an idea of what you're doing. You can go in there to discuss the personnel matters over which you have jurisdiction, which in almost all of your cases is going to be either your president or chancellor, and nothing else. And that can be done in closed session to do their evaluations, to discuss their performance, to bring up problems that are going on of a personnel nature with them. That's all legitimately in closed session. But as I said, you can't take any action back there. There have been numerous cases about that. You still have to come out into open session and call the agenda item back up and then take your official action where the public can see it. A couple of things that happened in the legislature last time around, and of course they're coming back, so I have a job for at least 2 more years, because I know they're going to change many things. But they've now required larger community colleges to post their agendas online and to broadcast their meetings over the internet. I did that because I don't know what it means to broadcast something over the internet, but that's we're mixing 50s technology and 21st century technology there. But so if you're a community college of the right size and you aren't already doing that, you need to get on the stick and comply with the law there. And that's a really important thing. I find as a matter of open government, getting the meetings to where they're videoed and available to the public, even if you don't live stream them, is really helpful. I've spent many hours listening to people's meetings because that's what most people do is they just tape record them. And you just can't get a lot. Sometimes the people don't talk in front of the mic very well, or you can't see facial expressions, or you can't see documents that are being exchanged. So I urge every governmental body I ever speak to figure out some way to somehow video your meetings and put them on the internet so that people can see. If you have committees, and I know many of you do, generally they don't have to be posted if the committee is merely advisory, and if the committee does not contain more than a quorum of your board. The problem can arise when a quorum of your board is going to show up anyway. If everybody knows the finance committee is meeting on Tuesday, and the finance committee is 2 members of the board and the CFO and the president, but then the other 7 members of the board show up, that's a meeting and it needs to be posted. If the committees are authorized at their creation or at some point during their operation with the ability to actually act on behalf of the governmental entity, it doesn't matter if there's only one of you on there. If the committee has authority to act on behalf of the governmental entity, it needs to be posted as a meeting. So those are just things to look at there. And of course, as I said, you're required to have training on this within 90 days of taking your oath of office. So if any of you are in that time frame, do take those trainings because there is a requirement for that. And in the last legislative session too, they made video conferencing a little easier for those of us that didn't already have, which is most of the community colleges. We didn't have a good way to do that. Now we do. It's just we have to have our presiding officer present where the public can be. Everybody else can be somewhere else and attending by video, which is amazing. The problem is the public has to be able to see all those other trustees, and those trustees have to be able to see the public. And so I know for some of my clients, we're still working on how exactly we set up a camera and video display array in our boardroom sufficient for that to happen. I know a lot of us sort of on the operational side of things and the staff side of things are worried that means that we'll never have a quorum of trustees in a place at one time again, that everybody's just going to call in from somewhere except whoever gets stuck with running the meeting. But I haven't seen that happen yet. That's just kind of a worst case scenario that we have nightmares about. Now, the last thing I want to talk about is some issues about open records. The thing you need to think of in general is that according to the statute and the Attorney General through every party's group of attorneys general have felt the same way, all governmental records are public. That's the starting point. Everything is public. There are, as there are with closed meetings, there are a number of exceptions for why you can withhold public documents. But the fundamental basic understanding everyone needs to have is whatever the government produces, whatever the government is retaining in the way of documents or information is public in some way or another with very limited exceptions. There has been a problem for years of well, what about email generally is considered documents or information, right? So your emails about public business are public. Many people thought, well, if I'm emailing about public business on my home computer, that's not the government's information, that's my information. It's my machine, my internet, I'm paying for it, my software. And the Attorney General has for years said that that's not the case, that it doesn't matter where the information is stored or how it was created, if it is of a public nature and you hold a public office, then that information is public. And so there was a lot of arguing going on about that. There was a case actually winding its way to the Texas Supreme Court of a county commissioner in Bexar County who refused to turn over information from his computer. That he said, this is a violation of my right to privacy, this is my equipment, my machine. And the talking point they have on that side of the argument is that the statute says it has to be information maintained by the government. And the argument is, well, they don't maintain my computer, I maintain my computer, and they don't have any legal right to my computer. So last session in Senate Bill 1368, the legislature solved this for us. They just came in and said, it doesn't matter where it's stored, it's public if it's about public business. So the argument is over. I'm not sure what happened to that case. It was at the Austin Court of Appeals last I saw, but and it may be different because it's under the old law. But so that's one aspect of it. Your personal computer is not a safe haven for you to conduct a lot of public business, and no one will ever know. It leads to problems, when people do an open records request and say, I want to see all the emails from the Board of Trustees to the president about this topic. We just have to ask you, do you have any emails about this? I hope you're all honest and produce whatever you have, but we run into that problem then. I'm not going to show up at your house and hack into your computer or hack into your email account and try to find out if you're lying to us. But should there be a lawsuit about that topic, people could obtain subpoenas at that point and they could actually get into it. And much like with open meetings, there are also penalties of up to 6 months in jail for violating the Public Information Act as well. So if you get an email like that from your staff saying people have asked for all documents about this topic and you have it on your own personal email account, you need to turn it over. A way around that, and the best solution I've seen, is to just have everybody have an email account with the governmental entity. And then you all need to be disciplined enough to have that be where you actually conduct your public business. And I'm surprised a lot of times at the number of governmental entities that don't do that. I don't know how many of you have that or don't, but it's much better to have a central email account because then the college or the university is going to store the information. When people do open records requests, we can just go in and search that. We don't have to bug you about it. And if it's in your account, we're going to take it out. If you go in and start deleting things out of your account, usually everything that's in that account is being duplicated somewhere else in the system. So we'll be able to go to the backups if we need to. It's just a much easier, better way. And then, like I said, the only issue is you have to actually do that. You can't. And what I do, a lot of times, I'll get email from clients from their personal accounts. I'll respond to that account, and I'll respond to their official account. So it goes back straight into that account, so that I'm at least trying to maintain this discipline of it goes into that account. The other thing the legislature did in this same Senate Bill 1368 was to clarify another issue that has been of concern to everybody, which is what about text messages? I don't know how to get a text message off your phone and produce it to somebody who asks for it, but there are ways to do that. You can do screenshots. There is software that will take it out of the system. The legislature went ahead and put in the definition of public information text messages. So those of you that have been trying to avoid having a record by not using my email account, but by using my text, that too is now public. And again, if we get a request that is broad enough to include that, we're going to come to you and say we need to see what's on your phone. And we'll need to figure out a way to get that information off if it exists. Generally, if you're just talking about scheduling meetings and things like that, that's okay. But if you're conducting substantive public business on text messages, you need to retain that. There are document retention provisions in the local government code and in the open meetings law, open records law. And if you destroy public records intentionally, that also can get you put in jail. So it's a complicated world, and I don't envy any of you. I'm out of office now, so I don't care anymore. I can talk to whoever I want, whenever I want, as many times as I want, and I can text them, I can email them, and I'm happy. But you all are in this position, and as I said at the beginning, this is kind of mechanistic. The statute is very, very strongly defined. The courts enforce them very strongly because the legislature has said in the open government laws, both the Open Meetings and Public Information Act, that it's important to the functioning of government that it be transparent and open to the public. And that needs to be more than just something the legislature says and something you say occasionally. If you've got public information, make it public. If you're in meetings, do your business in public like you should. And sometimes it'll get messy and sometimes it won't look very good. But at least the public will see what's going on and they'll know what you're doing and it'll be better overall. And I think I'll turn it back over to Bill.
Thank you, Cobby. And Donna Cornell will be our last presenter. Donna's going to cover conflict of interest and other related aspects of governance.
So I thought I might just follow up a little bit on Cobby's point, because I think one of the key points when you're talking about open records is maintaining them. And I think that's one of the things that catches people by surprise. How long do I have to keep those documents? You know, how long do I have to keep those text messages? Especially when you're maintaining them on your own system, it can become unwieldy and almost impossible. So I encourage you to talk to your counsel about how long I need to keep. The statute on records retention is very prescriptive about how long you keep each type of document. So I really encourage you to look at that and discuss that with your counsel, because that is one of the keys that's going to keep you out of trouble. There are a lot of types of communications that are not intended to be, you know, official records and maintained forever that you could get rid of in short order. But there are others that where you're really conducting official business that are things that need to be maintained for a set period of time. That's defined by statute, typically 2 years, sometimes a little longer. So I encourage you to look at that with your lawyers. I wanted to talk to you today a little bit about ethics in general and conflicts of interest. I'll get to it. I'm not quite ready yet. It's okay. I've got some slides for you. We're going to go through some case studies. But I wanted to talk to you a little bit first about ethics and conflict of interest in general. You know, a board is obligated to stand for ethical behavior. What does that mean for all of you? Really, it's doing the right thing, following the law, following the rules, understanding your governance structure, doing the right thing, giving everybody an equal chance. How does that manifest itself in your day-to-day work as regents and trustees? One thing is you should all present and insist the people that are under your control, your chancellor and senior management, under that chancellor or president, depending on the case, exhibit the appropriate behaviors. But you all have to exhibit those same appropriate behaviors. Again, doing the right thing, ethical behavior. Many of you, we do in our board, require our regents to sign a code of conduct where they actually sign our board adopted under one of my previous chairs, who's sitting here, a requirement that the regents sign that code of conduct every year so that they look at it, aware of it, and take responsibility for it on an annual basis. I really think that's good practice. It's not required by law, but certainly best practice sets the tone. The tone is always set at the top. You all know that from your private businesses. So I would encourage you all to have those codes of conduct. It's going to cover things like conflict of interest, relationships with vendors, privacy, confidential information. You will get lots of confidential information and how that is used and not used. It should cover things like, or can cover things like discrimination, sexual harassment. That's a big issue. I know you all may be discussing, I don't know, Title IX, which I know has been in the media tremendously and should be something on your radar. Those kinds of things I would expect to see in your code of conduct. And gifts and acceptance of gifts and what are the standards for that, which is something we will talk about. Code of conduct, channels for people, another best practice code of conduct, channels for people to bring forward to you or to administration, questions and concerns. Do you have a process in place, an anonymous reporting system many institutions use? There are different ways to do that, not one set standard, but it's one of those best practices, ethical conduct. Many of you see it in the private sector after some of the traumas in our public world after Sarbanes-Oxley got it adopted. That will be part of your day-to-day business. It has not been part of day-to-day business in public setting, but it's something that we have implemented at many institutions, including mine. So we have an avenue for people to come forward and complain. We have a hotline. We make sure that those things are not just brought forward, but investigated, and then we close the loop at the end. Sometimes you will find that the investigation occurs, everybody knows, maybe in some cases something is happening that shouldn't, but has the loop actually been closed? So that's, part of our best practices, tone from the top, best conduct, and have training. This is an example of the training. Ensure that I actually sit down with our board right after they become sworn in and provide them some training. That's something I would hope that you all get as well. So those are kind of like the best practices in terms of setting what I consider to be the tone from the top and good behavior, doing the right thing. The Texas legislature has kind of been much more prescriptive and not as general with regard to conflicts of interest. They're on one of the sheets that Fernando gave you. The conflicts of interest section, it comes from the Texas Government Code. Talks about gifts and bribes, your professional and business activities. This is on the document duties and ethics of public sector board members on the second page. Employment, investments, so we'll talk a little bit about those. A board member cannot have their personal private dealings interfere with or pose a conflict as it relates to your duty of loyalty to your institution. So your personal business, you have to keep separate. If there is a transaction that would have a personal interest in, you need to step back, step out of the room, and disclose that to your fellow board members. It's not that the proceeding cannot go forward, it can go forward, but you must disclose a personal interest or conflict in the specific transaction. The conflict of interest and business dealings, these issues that the Texas legislature has set out, is only, to me, one section of kind of the two main areas of risk or focus from the state law standpoint. The other one relates to gifts, and those are kind of what I consider the should-nots. We don't take bribes. Well, that's kind of a no-brainer. Everybody kind of understands that. It's set out in the penal code. Yes, those things all apply to you. But how could it catch you short, even unintentionally? And so that's one reason why I wanted to have some of these case studies for you today. There are exceptions, and those things are going to be the types of situations you typically find yourself in, where somebody is, buying you a lunch, and it's fairly, you're at, where would we go to lunch? Sonic, or at the hotel here. Your bill is probably going to be less than $50 a person. The Texas legislature has kind of set out $50 as kind of a guideline for things that are not considered actual gifts. There are times, and I would encourage you to ask your counsel about specific gifts so you can get that specific piece of advice when you are in doubt, because there are a lot of exceptions that can come into play that exceed the $50 threshold. The $50 threshold is just a bright line that makes it easy for you. But if it's over that amount, there are exceptions that would be allowed. Especially, you will find yourselves, for any of you that are involved in helping your institutions in philanthropic activities, where you will be with a donor or a potential donor, and there will be an exchange or a sharing of a meal or going someplace, and the bright line is not $50 in those situations. So I would encourage you to have those conversations because they are very specific. The other types of gifts that can be permissible can, in fact, raise an appearance of impropriety. This is one of those things where it may not be illegal, but it will look bad. So even though I'm going to advise my board what is the strict standard, I want you to also remember there is also the appearance of impropriety. And those are the kinds of things that can be more damaging to your institution than even following the strict bright line rule and law. And oftentimes those are unsolicited, be unsolicited gifts, maybe not something you want to accept. What do you do in that situation? Or maybe you do accept them in perfect innocence. And I'm going to ask, Kabi was having a conversation with us today at lunch, had a fabulous example from his experience, and I told him I was going to ask him to share this story with you about a gift that they received while he was on the city council.
Yeah.
And nobody really realized it was wrong, and what happened.
So the situation was we were building an arena in my city, and we were negotiating a deal with the Dallas Stars to put their minor league hockey team in there. And over the course of many months of negotiation, we finally arrived at a deal. The Dallas Stars sent down a bunch of people to the signing. You know, we were going to prove it at a council meeting in public, of course. And they sent down their, vice president and a couple of players and things like that. At the meeting, they presented us all with game sweaters. And they had our names embroidered on the back. And we all put them on as we signed the deal. We wore it on the dais while we approved it. Then we took a break. Everybody went down. We all stood around. Guys were there with hockey sticks. And, the media was there. I think it was on Channel 24 News. The paper was there. So there's no way we could hide the fact that we'd gotten these jerseys. We didn't think anything of it. The negotiations had taken place for a long time. We didn't know they were going to do this. They just showed up with it. And we thought, good photo op. Let's all wear Dallas Stars jerseys with our names on it. And our city attorney contacted us. So we wore them, we went home, stuck it in the closet. And we don't have any experience at that time with hockey, so we didn't know what a jersey is worth. And our city attorney contacted us all a couple days later and said those jerseys cost about $270 without the embroidered name on the back. And with the embroidered name on the back, they were well over $300. And so we'd all received an illegal gift. And a way out of that is to give the illegal gift to a nonprofit or something like that. So we all donated them to the city. And I've never seen my jersey ever again. When I left office, I said, "Can I have my sweater now?" And they said no. I don't know where they are. I don't know if they're in City Hall somewhere or if they burned them out back or what. But we did not know we were breaking the law. Luckily, no one prosecuted us about it, and we covered it by giving it to the city for the city's purpose.
So gifts are one of those things. But yes, when you get an unsolicited gift, there are going to be things that you shouldn't be accepting, and what do you do? And yes, giving them to a charity is one of the exceptions in the statute. Again, I would talk to your council about when those kinds of things occur.
Just for the record, our city attorney had one too. So in that case, talking to our council didn't really...
It didn't help you.
No one knew. We just had no idea. We just thought, it's a jersey. Was it $25, $30? But
right.
It was an actual game sweater was the thing.
So one of the other things I wanted to share with you about conflict of interest before I turn to the slides is in doing my research, reading everything out there on conflict of interest as it relates to governing boards, especially higher education. I'm sure many of you are familiar with the Association of Governing Boards, which has set out a pamphlet on conflicts of interest, and they set out their best practice and their standard for conflict of interest. And it reads as follows: if reasonable observers having knowledge of relevant circumstances believes there's an actual or apparent conflict of interest, the board member shouldn't participate in acting on that transaction. Now that follows our statute. Their statement goes on, and this is why I wanted to bring it to your attention in case somebody starts talking to you about this. They go on and they say, well, if there's a compelling benefit, if there is a real advantage to the institution, then maybe you could still, that trustee or regent or board member could still participate in the transaction. Well, that would be contrary to state law. So that would be an exception that wouldn't be applicable for us. And even though it's set forth as best practice, I think it follows more of the traditional private sector standard for conflicts of interest, is not one that I would recommend in the state or public context. So I wanted to talk to you a little bit, and hopefully I'm going to I wanted to go through some case studies. I'm going to get my colleagues here to participate. I encourage my board, who some of them are here, not a quorum, as they were quick to point out to me. I know they know the answers to all these questions, so this should go really quickly. But if you have questions along the way, if there's another version of this scenario that you have a question about, I encourage you to ask us, and one of us should be able to help you. So our first scenario, you see here on your screen, you've got it in your papers in front of you also, so if you wanted to take some notes. But, and this is one that definitely will come up in your experiences, almost undoubtedly. And I will say that my board has had many robust discussions about this very issue. You get a call from a friend asking you to intervene on behalf of his daughter who wants to be admitted into the university as an undergraduate, but may not have the qualifications to get admitted. How do you respond? Is it okay? So the real question I have for you, is it okay to write that letter of recommendation, and how do you sign it? So who's going to answer the question for me? Or am I going to answer it myself? Fernando?
This is a regent's daughter?
No, not a regent's daughter.
regent's
You've got a
friend's
friend.
daughter?
Yeah.
Yes, and so the regent,
Well-
they're coming to the regent, let's say Regent Armour sitting there, and they go to Regent Armour and a friend of his, they want to get, Regent Armour, can you get help my daughter get admitted into, the business school at the university? What do you tell them?
Well, I would tell them that you cannot make a call that insists or suggests that the admission ought to occur. You also tell them that I can put you in touch with the right people who can guide her and counsel her as to the admissions process. You can call, I suppose, and get materials sent to her, but you cannot split your loyalty. You cannot, as I suggested at the inception, skip the chain of command and go tell the admissions counselor, this is a really good kid, I know the grades aren't there, you really ought to let her in.
So longtime friend, Regent Armour has known this young woman for her entire life. These have been family friends. He wants to sign it only in his capacity as an individual, certainly not as a regent. And then what?
Well, that's a tougher question, because he still couldn't do, in my opinion, what you suggested. What he might possibly be able to do is, along with other letters of recommendation, make or write her a recommendation. But even that gets kind of dicey, because he is a regent, and people are going to say, well, he really wants her in, I really don't want to offend him. I think the best thing to do is just what I've suggested. I think even for the long-term friendship, sometimes you have to let those pass. And if it's a longtime friend, they'll hopefully understand that you do have a sense of duty and a sense of ethics and a sense of honor here.
Yes, sir.
The applicant were to not meet the qualifications. You don't know if this applicant doesn't meet the qualifications. Can't you write, and if you've known the applicant their whole life, just simply write a letter saying what you know about them and be truthful.
I don't think this is one of those things where I don't think there is an absolute answer, right or wrong answer, which is what many lawyers are going to always tell you and frustrates clients all the time, because you can't tell them absolutely yes or no in each specific situation. It really does depend, in my view, on the totality of the circumstances. If it is somebody you've known for your whole life, I don't think it's necessarily wrong to write a letter of recommendation in your own capacity. Some lawyers out there are going to advise you differently, that it creates some kind of undue pressure on when you write the letter to the dean or the admissions committee, and that undue pressure creates, at the very least, the appearance of impropriety or a conflict of commitment, and is something that's better not done. But again, those are very difficult questions to answer in absolute, based on a scenario that is not particularly detailed, and to some extent you will have to be able to justify it down the line.
You might want to look too at if you have a locally adopted ethics standards or conflicts of interest rules. I have one client that it's explicit in their their ethics rule that no member of the Board of Trustees may attempt to influence any decision by any member of the college staff. Mm-hmm. So even writing a letter of recommendation is an attempt to influence a decision. And so we interpret it very stringently and say you can't do that.
Well, I know you disagree with that, but consider this. If somebody who's a non-regent and knows an individual, say this person's neighbor or this person's classmate, and has known that individual all of his or her life, he or she would write that letter of recommendation for the individual. It's going to be treated routinely in the admissions office. The letter's going to be given a certain amount of weight based on its content. And the problem here is the letter from the regent is given weight, perhaps not just on its content, but on basis of the position that the regent holds. And that's the problem. In fact, the law does say, with respect to the acceptance of gifts, if you accept, let's say a president gets offered a gift of golf clubs by a regent, and say the regent is the president's brother-in-law. Well, I think that's fine. There's an independent relationship. But if the relationship does not exist independent of the regent's status as a regent, then that's where you have the problem. Because others would not get that same consideration who are maybe as meritorious as the young lady in question.
Okay. Yes, sir.
I like the thought that my colleague over here presented, and let me just kind of piggyback on it. What if the president and the board chair made clear to the admissions office there's a protocol for handling these kinds of things, and made it very simple. If they want to write a letter, they can, but you are honor bound not to take it for more than substance of the letter, or something of that nature, so that the admissions people aren't in this quandary of deciding what to do.
I had a former board chair always put at the end of he chose to write some of those letters, not many, but he would always write at his last phrase was, please consider this individual on his or her own merits, to try to get to that same point that you raise. Yes, Regent Shaw?
So last year, I served on the undergraduate admissions committee before becoming a regent. And one thing is that when we saw applications come by, we saw recommendation letters come by. When we saw applications come by and we saw recommendation letters come by, it was only natural that when there was a certain, salutation or a certain, a title that we saw that brought attention, even if we tried to ignore it, it had priority. Even if you put something at the end of the line, it had priority, and we tried, but people, it's just a natural process of thinking. So just a general recommendation is just don't write the recommendation letter just to keep yourself and the student out of trouble in the future. But that's what I would say.
It kind of goes back to Fernando's example at the beginning of his presentation about the begonias disappearing. You don't know what the effect that you have on the staff. And some staff are going to be very resistant and not care. Some of them will probably be angry that you did it and it'll be bad. But there are a healthy number that are like, oh, a regent has requested this and I've got to grant it more weight. And that's...
And why do we have ethics? And why do we have ethics laws? One very simple reason, because you have power. You have authority over a lot of people, over the management of money, over personnel. That's why you need these ethics codes. And I know I view them very strictly, and I know that so many of these things can go both ways, but I'm always going to err on advising you with respect, as Donna said, doing the right thing. Now, you may choose not to take that advice, and that's fine too, but I think a conservative approach in these areas is appropriate.
Yes, Regent?
One-
Yeah,
Go ahead.
I think there's no right answer to this. I think it's up to each individual regent. The old saying, I think it's hard to unring the bell once you've rung it, and it's hard to say, even with a disclaimer, that it may not be perceived a certain way by a member of the committee. What's also telling for me is, from personal experience, I don't write them, but those of you who are university regents in the room know that very recently we all received Public Information Act requests specifically asking for all letters or recommendations we had written for any students at our respective universities. So, the fact that it has a lot of interest from the public, I guess it's one of those issues, as Donna mentioned, that could have the look of impropriety depending on who's writing the story and what they're writing about. So the conservative approach might be not to write one, but I think it's going to be, at the end of the day, up to each individual regent.
One thing I would like to point out is whether, and it may be that there really is no right answer to this, legally speaking. However, what I would want to point out, and some of you, if not more, may be aware of the situation that occurred at the University of Illinois system over the last couple or more years. And this practice of regents writing letters on behalf of prospective students to get into the University of Illinois at Urbana-Champaign, which is a flagship institution and a very fine school, came to light. And from the governor on down, the newspapers in Illinois castigated politicians, the regents, you can go right down the list. So why did they do so? Not necessarily because it was violative of any law, but rather it was the appearance of impropriety. It was the appearance that because of the regent's authority, because of their power, they were going to bat for somebody who was going to get favored treatment over the sons and daughters of the general populace. So it was the appearance of impropriety that really harmed the reputation of the University of Illinois system, and in particular, the flagship school. So just keep that in mind when you're dealing with these kinds of issues, as Donna's going to be bringing along. While they may technically not be illegal, always ask yourself, how would this appear on the front page of the Dallas Morning News, et cetera?
Right. Here's our next example. You were approached by an alumnus who is also an architect, and he wants you to help him in his bid to land a major university project. What do you do?
I think you ought to let them have a shot at this
Okay,
one.
great. Okay.
Don't make me answer it.
Anybody willing? All right.
I tell him the process by which you can be heard.
That's the way to do it.
That's exactly what I would recommend. You let them know what the process is, who to contact to get access to the procurement process or the bid process, depending on the case, and leave it there. And more than that, and you are probably asking for a serious trouble. If somebody just came forward and asked you, I don't think that's necessary. Well, our board does not vote on particular vendors. I know some boards do. Our board delegates that authority downward. They vote to approve the expenditure of funds, but not the actual contractor. I suppose that would be something you would have to evaluate again on a case-by-case basis. If you felt that it was too much of a contact, then yes, you could recuse yourself. If you want to, if somebody comes to you and wants an introduction so they can pitch a sole source contract or get a preference, what's the best response? Again, I think it's the same kind of response. Here's the process. These are the people you can be in touch with. This is the website, and leave it there. And we'll go on to the next one. You are invited by the president of one of the campuses to visit the campus and meet with officials interested in donating land for the campus. What is your proper role? Is that a meeting you should go on? Is that appropriate?
Absolutely. That's in the statute.
Right.
You support the president's taking the lead, you're not usurping anything. I'd let the chairman of the board know that you're doing that. I think it's entirely appropriate for a region.
Yeah.
We need you to help us raise money.
Right.
That's a good thing.
But, yes, exactly. Thank you. You get a call from the governor's office insisting that you vote against any tuition increase because the governor is concerned that it will hurt his reelection bid. And I don't know if any of you all saw the Associated Press article today, that discussion that's going on at the University of California about this very subject and raising tuition rates and the pressure that is coming back on the institutions and how the individual trustees should vote in that particular circumstance. What is the proper way to handle this?
Ask them. Pick on somebody.
Mr. Henke? No?
I mean, I don't think you should do it. I think it's pretty obvious.
It's always important to be respectful. Again, you do the right thing. Your duty of loyalty is to the institution and not to the person that appointed you or the senators that are confirming you. Your duty of loyalty is to the institution.
And if it is a senator or a legislator, you've got another problem. You've got a separation of powers problem, and the Constitution of the state of Texas talks about separation of powers. This is not a legislative prerogative, and you will get some of those calls, I promise you. And as Donna said, the proper response is to be respectful but remember where the primary loyalty lies.
The loyalty is to the institution and ultimately to the board's final decision, even if you, you will have situations where not everyone agrees with a decision that a board is making, especially with regard to tuition and tuition increases. It's a big topic these days. You need to be ultimately respectful to the institution, and that is the decision of the board as a whole. Whatever the board ultimately votes on is the position that you have to carry forward. Yes?
I just had a question. Would you be able to cover a hypo that addresses social activities between board members and your regent or your chancellor or your CEO? Just something that comes to mind are dining activities, or and who's picking up the tab and what you would recommend or consider appropriate or inappropriate, and whose ethical duty is it? Is it the board or the president, or how? I mean, without going into too much detail, because this is obvious. I think these are pretty obvious as far as someone from the outside contacting a board member, but I'm talking more specific board member and president or chancellor.
And who's going to
Pick up the tab.
tab
What if family members are there and everyone's having a good time, and just, I mean, is that subject to to open records if someone were to find out how? I think.
Well, it depends on who's paying for it. I mean, if the board member is paying for it out of their own pocket, no, I don't think it's subject to open records. If you go have a social dinner with your president or chancellor, your duty, it depends on what the purpose is. I mean, if it's just a pure social activity, I think there's nothing wrong with it. If, in fact, the chancellor is the one picking up the tab and spending state funds or even foundation funds, typically those requests for reimbursement are come through the administrative processes of the institution, and yes, those would be subject to open records. Is it wrong necessarily? No. Could it have the appearance of impropriety? Yes. Depending on how many times, how much was spent. Those are the kinds of issues that have gotten presidents in trouble in the past. Excessive spending, that is something that people are always going to be cognizant of, and how much people are spending at a particular nice restaurant could certainly be something of some scrutiny. And yes, those are administrative records of the university that could create some unintended publicity, negative publicity. So, yeah. So here is my next scenario. You have an idea for a new academic program and you approach the relevant dean. He would like you to help promote it to the provost, to help secure some gifts for the program, to advocate for new faculty lines, startup packages. You have ideas about the curriculum and some guest faculty from the community that you would want him to include in the proposal. What kind of problems do you see with this?
Don't do it.
Where should we start?
Yeah, I mean, obviously, you're well outside the chain of command, but beyond that, you're, attempting to influence the operations of the college, and that's not your job. I would say if you have an idea like that, you need to bring it up with the president or chancellor and see if they agree, and if they want to either make it a topic of discussion at the board level, if it's appropriate for that, or, kick it to somebody on his staff to look at, but it's not your job to go put it together and make it happen.
Your policy-making bodies, not management bodies. You make the decisions about what are the general policies of the institution, not the specific, day-to-day details of academic programming.
Now, I guarantee you that the president or the chancellor, as the case may be, will listen to you, and they should listen to you. It may be a great idea, but at that point, what happens? It goes eventually to, the faculty is involved in this, And that's way down the chain of command, because they're the ones that, to a great extent, generate the curriculum at an institution. And if you look at your statutory chart that you have in your packets, that's laid out for you. They'll listen to you, but then eventually it'll go to the campuses. They'll vet it that way, and then it'll come up through the curriculum committee or whatever committee, academic affairs committee. And at that point, you start getting regional input, and then eventually the full board, and it could happen, but you have to run it through that process.
You are, yes.
Oh.
You are approached by your neighbor, a Texas Supreme Court justice, asking you to have a lunch meeting with members of the Supreme Court, and you're a lawyer. It's suggested that the purpose of the meeting is to discuss replacing the law school dean because of complaints from alumni about his arrogance.
Whoa.
And I know the initial think is what law school dean would not be that. So. You would expect that to begin with. Other than that piece,
I think it's in the job description.
how would you handle this situation?
Well,
Now,
Donna,
you're a lawyer, so let's say you're a lawyer. It's going to be awkward for you to, at time, might be, you might feel it is awkward for you to reject a meeting with the Supreme Court justice. That might feel awkward to you. It might not to do so. So that's an issue. Getting involved in the decision-making process of who is and who is not a particular dean, again, is not the role of a policy-making body. That is a couple levels down, although it's a highly charged school. Law school is one that a lot of people have a lot of opinions about. Any other thoughts?
yeah, Donna, you've also got a separation of powers issue, and and this has actually happened in my career several years ago when a member of the legislature called the chancellor and me over and said, I know more about that institution and how it runs than the administration, and they're making a wrong decision with respect to the tenure of a faculty member, and you need to fix it. And all you can say is, respectfully, we don't have that authority, and don't think that you do either, with all due respect. And I think you can maintain the relationship, but you need to be mindful of this, because your first tendency, especially if it's somebody prominent, is to try to accommodate. And so you need to remember that you're part of that board that Cobby was talking about, that quorum.
It's true, and I agree, and this is going to be one of those situations where I think, again, it depends what you do with the information. I think if you provide the information to the appropriate folks, you listen to the conversation, and then you provide on the information, I'm not so sure that's wrong. Yes, you were invited because you're a lawyer. You are also a regent and connected, or a trustee, and you're also connected to that institution. I don't think it's necessarily wrong ethically, or even has an appearance of impropriety, absolutely. I think it really depends on what you do with the information and how you assert your authority into that particular situation. A lot of people there will be people out there that will advise you, absolutely, you never should do that. You just, stay in your little lane that is supposed to be a region, and you just stay with your little region pool, but that's not reality. That's not the world in which we live.
I mean, as a regent, is it wrong for me to allow anybody, Supreme Court justice or man on the street, to express an opinion to me about anything regarding the university that I help to govern? It's what I do with that information and how I go forward. But
exactly
anybody can come up and say, well, I don't like y'all's president, or I don't like y'all's dean. I mean, so what? I'm listening to somebody's opinion.
Right.
Absolutely agree.
Absolutely.
With one exception, you can never hear anything bad about the general counsel.
Turn them away.
Yeah, Well, that happens too. We don't always tell people what they want to hear. Here's another scenario. You're asked to help get tickets for an event on campus, athletic event, whatever. It could be a arts event. Is it better to provide the tickets or assist in getting access? Well, not necessarily. I don't think it's necessarily wrong to suggest that we provide tickets to a potential donor or friend of the university. I don't think that's necessarily wrong. I think there are scenarios that you could dream up out there that would feel wrong to you. And in those, this is one of those things you got to go with your gut check, which again, at the beginning I said, does it feel right? Is it right? If it is, okay. If it's not, you'll know it. I mean, there's going to be no doubt in your mind. This scenario in and of itself, probably just fine. But there are going to be situations I could come up with where it really wouldn't be okay. And you are going to know those when they come to your attention. And when you have questions about it, those are the things that you can go talk to your counsel about. What do you guys think? Agree?
Yeah, that's another situation we discussed at lunch, and yes. Especially with the person asking you in your capacity as a region or trustee to help him or her obtain tickets, I don't see any problem with that.
Yep.
I know of universities that week in and week out invite potential donors.
Hopefully.
Right.
Should be.
So.
Okay, my last one. A faculty member approaches you to discuss concerns she has with a dean and his handling of a tenure matter. How do you respond? What do you think? Yes, sir.
I think somebody already said it. There's got to be a protocol for it in
Correct.
the university.
There absolutely is.
Let them know what it is. They already know. Let's say that's all I can do.
Yeah. There's really, typically, a board is going to make the final decision on a tenure matter, both granting and revocation of tenure. And so interfering at an earlier stage would be highly inappropriate. And yes, every institution that grants tenure has a very, very, very prescribed process, almost exhaustingly so at times. And so that is really something that you should not involve yourself in. Those are the scenarios I have for you. I know we're going to be available for questions, but thank you